Hi everyone, thanks for coming. My name is David. I'm the president of the Moot Court Board, and I'd like to give a quick short round of applause to our finalists for making it through the finals. You guys, they beat out, I think, 49 people, so this is a really big accomplishment, and I've gotten to see Daniel argue. I haven't gotten to see you argue, but I'm sure you're great. and I'm sure that it's going to be a wonderful round. So again, congratulations, and also welcome to the Moot Court Board.
Thank you to everybody for coming out tonight. My name is Jessup Veile. I'm one of the 3 Jessup Cup coordinators. Zan, Brent, and I would like to thank you all, as well as our faculty judges who have come out this evening and spent time to prepare for this competition. We'd also like to thank Laura Grissom and Shara Ashley in the events office for helping us put this together, and the Moot Court Board members who are here tonight, and everybody else who has helped judge leading up to tonight's event. In particular, a special thank you to Khan Oljan for going above and beyond and helping us. Without you, it wouldn't have been able to pull this office anywhere near as smoothly. And most importantly, we thank all of the 2019 participants. It was an excellent event. It was great to be a part of. I'd like to quickly just introduce the 2 finalists this evening. So we have Daniel Clarin. He is a member of the class of 2022 from Rock Hill, South Carolina. He earned his BA in political science from the College of Charleston, and before law school, Daniel worked as the education director for a nonprofit organization that provides free presentations on the impact of modern agriculture. He also competed on his college's mock trial team. And from the class of 2021, we have Allyson Veile, who earned her BA in economics and government from the University of Texas at Austin in 2018. At Duke, she is a staff editor on Law and Contemporary Problems and the Duke Environmental Law and Policy Forum, 2 journals. Allyson also enjoys cookout and milkshakes, the West Wing, and spending time with her dog, Fluffy. I'd also just like to briefly introduce our faculty members this evening. Professor Curtis Bradley, sitting in the middle, is the William Van Alstyne Professor of Law and Professor of Public Policy Studies at Duke University. He is also the co-editor-in-chief of the American Journal of International Law and as a co-director of the Center for International and Comparative Law at Duke Law School. Professor Laurence Helfer is the Harry R. Chadwick Senior Professor of Law at Duke Law School and is also the co-editor-in-chief of the American Journal of International Law and co-director for the Center of International and Comparative Law. And finally, we have with us tonight Professor Jayne Huckerby, who is a clinical professor of law and the inaugural director of the Duke International Human Rights Clinic at Duke Law School. Brent's going to introduce the Jessup Cup and the problem for this evening.
So the Jessup Cup is an international moot court competition that focuses on international law, if you didn't get that from the backgrounds of our judges tonight. It's been going on now for, I think, over 50 years, or it's in its 5th decade. And each fall, Duke Law puts on an intramural version of the competition here at the school that's open to students from all classes as well as LLM students. This year's problem focuses on 2 countries, Arak and Rakab, that share a highland region that is home to the Kylef yak, which migrates every year in between the 2 countries. Rakab has developed a medication that's highly successful in treating diabetes and obesity problems using an enzyme from yak gallbladders, and hunts the yak regularly in order to manufacture that medication. Arak, on the other hand, has been using the yak for centuries for cultural and religious purposes, and they also hunt the yak every year. And the 2 competing interests on Arak and Rakab have led to tensions as the yak's population has declined over time. If you're interested in the full set of facts, they're in the programs that were available at the door. But with that, I'm going to turn it over to our competitors Tonight, Daniel will be arguing for the applicant, so that's Auric, and Allyson will be arguing for the respondent, Rakab. Each of the competitors will have 12 minutes to present their arguments.
We're ready to hear oral argument in the case concerning the Kylef Yak, and we'd like to hear from the applicant.
Thank you. With the court's permission, may I reserve 2 minutes for rebuttal?
Okay.
Thank you. Good evening, Your Excellencies, and may it please the court. My name is Daniel Clarin, agent for the applicant, the state of Auric. This case is about a nation of indigenous people trying to preserve their way of life and protect an endangered species in the face of commercial interests. Accordingly, the applicant respectfully requests that this court find in its favor for 2 main reasons. First, because the actions of the company Dorta are attributable to the nation of Rakab, both under customary international law and under Article 5 of the Articles on Responsibility. Second, because the ongoing mass slaughter of an endangered species, the Kylef Yak, within Rakabi territory is in violation of Article 3, Paragraph 5 of the Convention on the Conservation of Migratory Species. I'll begin first with the argument on attribution of international responsibility. Article 5 lays out the conditions by which a private company can be designated a public entity for purposes of international adjudication. In fact, Article 5 says in its own words that it's intended for situations where former state corporations have been privatized. And that's exactly what we have with the company Dorta. It was started as a government agency, and for over 30 years, that's how it operated, taking up a substantial portion of the annual national budget.
Agent, is it your position that all privatized companies the actions of all of them are attributable to the state?
No, Your Excellency, not all privatized companies are attributable to the state. It has to meet certain conditions laid out in Article 5. One of them is that they perform a public function, and that certainly is the case with Dorta. They have a 100% monopoly over all prescription medication sales within the nation. They also have been granted discretion by the state to license their own agents to perform hunting of the yak. And so they are performing a public function by taking the place of what would traditionally be reserved for, say, a fish and game or wildlife services department.
So, counsel, just to make sure I understand the scope of your argument, are you arguing that every single action by Dorta, no matter what its context, is all attributable to the state?
No, Your Excellency, not all actions of Dorta would be attributable to the state. Only those actions which are considered internationally wrongful, specifically in this case, those actions which risk transboundary environmental harm. And that actually brings me to my next point.
Now, if it was a state-owned company, all actions would be attributable to the state. Is that true?
Yes, Your Excellency, if it was a state-owned company explicitly. Although Article 5 does say that the internal status of the law doesn't necessarily determine its status for purposes of international adjudication, that even if it's considered private within the state, it can be considered
So
public.
if this company committed negligence in how it designed the drug and it distributed it around the world and people died because of bad drug making, that would all be attributable to the state, or would it not be?
No, Your Excellency, that would not necessarily be attributed to the state because it would not fall into that category of risking transboundary harm as it's laid out in the Articles on Responsibility, at least as it's described in that document. Okay. Now, even if
we don't accept your Article 5 claim, right, which is the idea that Dorta is exercising governmental authority, do you have any other foundation for attributing the actions of the corporation to the state before we get to the wrongfulness piece? For the attribution piece.
Yes, Your Excellency. So even if this court is not fully convinced that Dorta is a public entity under Article 5, this court can still find in the applicant's favor simply by finding that the nation of Rakab had an obligation to restrain the unlawful conduct of a company operating within its territorial bounds. This court was very clear in Argentina v. Uruguay, the case concerning the pulp mills on the river Uruguay. This court said that a state is obliged to use all means at its disposal to prevent transboundary environmental harm. And this court went on to say that this obligation has been codified as a principle of customary international law. and that it applies both to public and to private operators. So whether we designate DORTA as a public company, a private entity, it still has an obligation, the nation of Raqab has the obligation, to prevent any activity which is risking transboundary environmental harm.
It can't be preventing any activity.
I'm sorry, can you repeat the
It can't be
question?
preventing any activity that might risk transborder harm. Then what is the content of the standard of what you're talking about as a due diligence standard?
Yes, Your Excellency. So it does require the due diligence and precautionary care standard, which says that if the nation has reason to believe that it could risk environmental harm with one of its neighboring states, then it has the obligation to use all means at its disposal to prevent that activity or to restrain that activity,
And
is the language.
Is that argument completely independent of the second argument in this case, which is about the international environmental law obligations of the country?
Yes, Your Excellency. So this argument about the obligation to use all means, that is with regard to the attribution of international responsibility, not with regard to the whether or not the actual hunting was itself a violation of environmental obligations for neighboring states. And actually that brings me to that second argument about the violation of Article 3, Paragraph 5. So this is contained within the Convention on the Conservation of Migratory Species, Article 3. In September 2017, that's when the yak was added to Appendix 1, which afforded the yak special protection as an endangered species. Specifically, Article 3 prohibits the taking of animals belonging to such species.
Now, how many animals are taken by aurochs population each year?
The most recent numbers are somewhere between 90 and 100,000.
And that sounds like a lot more than DORTA is taking.
Yes, Your Excellency. That number is higher than the latest numbers from the nation of
And what's
Raqab.
the basis under the treaty for auroch to take so many of the animals?
So, yes, Your Excellency, that's a great question. So under the treaty, the nation of Auroch also has obligations to limit their use of this animal except for the exceptions that are laid out in Article 3. And there are a few different exceptions. One of them is the use for indigenous people who are using this for a traditional purpose.
And
so
I saw that in the treaty. Do we know how many that would allow them to take? Is that infinite? Is it 100,000? Is it 10,000? How do I know?
So, yes, Your Excellency, there is not an upper cap listed in the treaty. And so that would depend on the actual context of the use in that respective nation. When it comes to the nation of Raqab, their use of the yak in that case, that 28,000 that was slaughtered in January and February of 2018, does not fall into any of those special circumstances that are laid out.
No, I
under
understand your
Article
argument.
3.
We'll get to that in a second. But it occurred to me that if the aurochs population are taking too many animals, one way to reduce the danger of them becoming extinct would be to take fewer.
Yes, Your Excellency, that's true. And it is a legitimate challenge trying to manage the population of an endangered migratory species which moves between two states. One factor that is at play here is the fact that the winter migration season of the yak in the country of Raqab is taking place when the reproductive females are of age where they can actually breed. And so they are at a higher risk of vulnerability when they are in that winter migration in Raqab versus in the state of Auroch. So there is a distinction there in the way that these animals are being
Agent,
used.
I would like to just explore this court's authority to review these different exceptions that you're talking about. And in particular, I'd like you to explain with what degree of precision can this court review the scientific exception, which is what your opposing agent will be relying upon. Because in what I think I am hearing you saying is that when it comes to questions of the indigenous taking exception, that we should give a fair amount of deference to Auroch in allowing its indigenous population to take yak. But when it comes to the scientific issues, then you want this court to be much more involved. And I'm wondering if you can explain how you can justify that distinction.
Yes, Your Excellency. So there is a distinction based on the law as it's written in the treaty. One of the final requirements for an Article 3 protection that is in Article 3 of the CMS is that the taking of the animal, even if it does fall into one of those exceptions, must not operate to the disadvantage of the species. And so even going with the scientific purpose exception for the nation of Raqab, even if the court determined that the 28,000 was taken exclusively for scientific purpose, They would also have to find that it did not operate to the disadvantage of the species. And yet, the information from the record clearly reflects that the population of the yak has declined by 10% just in the last 2 years due to excessive yak hunting. So for the foregoing reasons, the applicant requests that this court find in its favor to protect the yak population, to preserve the indigenous way of life for the Pivsow population, and to hold the Huckerby government accountable for its violation of international obligations. Thank you.
Thank you. And we'll now hear from the respondent.
Good evening, and may it please the court. My name is Allyson Veile, agent for the respondent, the Republic of Huckerby. This case is about innovation, whether international law can allow new ideas or must crush them. Today, we ask whether Huckerby can continue to allow the manufacturing of a life-saving medication for people all over the world. Huckerby respectfully requests that this court rule in its favor for 3 reasons. First, Huckerby is not responsible for the acts of a private corporation. Second, Huckerby has not breached its obligations under the Convention on the Conservation of Migratory Species. And third, even if Huckerby had breached those obligations, this court should not enforce the Convention on the Conservation of Migratory Species against Huckerby in this case, because it would violate other principles of international law. First, and preliminarily, Huckerby is not responsible for Dorda's acts. The applicant has argued that under Article 5 of the Articles on Responsibility, the acts of Dorda can be attributed to Huckerby in this instance because of its governmental authority. However, Dorda is not licensed with any governmental authority under Huckerby law. An applicant has primarily relied on the fact that Dorda has a monopoly, a government licensed monopoly. However, a monopoly power to distribute one's medications has nothing to do with government authority. In fact, the comments of Article 5 specifically mention the police force and things of that nature, which is nothing like the Dorda's activities here.
Counsel, I have a question about that. So under Huckerby's current laws and regulations, could Dorda hunt the yak without a license from the government?
No, Your Excellency.
And does the government also determine the scope of the license, how many they can kill?
Yes, Your Excellency, it limits
So
them.
their entire activities are dependent on government approval?
Yes, Your Excellency. However, the actual licensing is a subject to general regulations. So any citizen can receive a license. So those acts do not become attributable just because of that license.
How did the government decide to allow them to take up to 30,000 yaks in a year?
Yes, Your Excellency. It was because of the number that they needed to take for the production of Galvectra. And it said that it could take up to 30,000, so however many it needed. However, it did not license specifically to take 30,000, just not over. But that brings me to my next point, which is that Huckerby has not breached its obligations under the Convention on the Conservation of Migratory Species. The applicant has argued that Huckerby is in violation of Article 3. However, Huckerby has complied in good faith with Article 3. Huckerby immediately revoked all of its licenses that it had previously issued when the yak was added to Appendix 1, and it issued Regulation AG 2017-0300, which only allows licenses to be issued when the Ministry of Agriculture considers that those licenses comply with Section 5 of Article 3.
Is it your contention, Agent, that a good faith compliance is sufficient and that requires deference from this court? If you can demonstrate good faith compliance, then this court doesn't make an independent assessment of the scientific necessity of the taking?
Yes, Your Excellency. The Vienna Convention on the Law of Treaties requires the countries to comply in good faith.
But in terms of this court's review, my question is something a little bit different, which is that if your government officials were to make a determination that it was appropriate to allow a certain amount of taking of yak, would this court have the authority to make an independent assessment as to whether, in fact, that scientific necessity had been shown, or would we have to defer to the findings of the relevant ministry of your government?
Yes, Your Excellency. It would be under the whaling case. This court has discussed the standard of review for scientific purposes. And in that case, the court did a modified standard of deferential review, which required objective evaluation of the reasonableness of the fit between the stated objectives of the program and between the scale of the program itself. And applying that to this case, DORTA has issued these RCAB has issued this license to DORTA under the scientific purposes exception and announced when it was issuing that license that it was in view of the scientific purposes of that medication.
Now, Counsel, isn't scientific purposes about the possibility of discovering new scientific knowledge? And it sounds like the knowledge is already here, and that killing more yaks is not going to produce any more scientific knowledge. So I'm having a little trouble seeing how I fit that into the exception.
Yes, Your Excellency. The DORTA is still researching new synthetic methods of yak. And also, this exception is more broad than the whaling case's scientific research purposes exception. The addition of that word research changes the meaning of the term, and scientific purposes can be more broad than that.
I want to take you back a little bit, actually, because I think we skipped a part of the argument by focusing only on whether or not the respondent was responsible for the acts of the private company. In particular, I'm interested in your response to the applicant's claim that there's a question of transporter environmental harm here. That even if we accept that this corporation is not attributable to the government, the government has obligation to regulate private actors in its territory.
Yes, Your Excellency. Under the CMS, RCAB does have an obligation to regulate the taking of species.
No, even more broadly than that.
More broadly, RCAB may have an obligation to regulate transboundary harm. However, in this case, there is no transboundary harm that is caused directly by RCAB. What's clear is that the culling of yak cannot sustain a 150,000 per year, but what's not clear is that they couldn't sustain a 30,000 cull from RCAB. So RCAB's actions do not directly cause transboundary harm in the absence of Uruk's actions. And that brings me to my next argument, which is that the CMS should not be enforced against RCAB because in this instance, it violates other principles of international law. The addition of the yak to Appendix 1 was itself a violation of the CMS. Article 3 provides that species are allowed to be added to Appendix 1 only if that species has been proven by reliable evidence to be endangered. Endangered is defined in Article 1 as requiring the species to be in danger of extinction. In this case, the only evidence that was relied upon was the studies by the Yak Life Sciences Association over just 2 years that showed a decrease of 10% in the species. With no other evidence, this should not be considered sufficient by this court under the reliable evidence standard. And secondly, the addition of the yak to Appendix 1 violates RCAB's right to use the resources within its own territory, which is equal to that of Uruk's.
But its right to use the resources in its own territory is limited by both its treaty obligations and its customary international obligations. Isn't that right, Agent?
Yes, Your Excellency, and the same goes for Uruk, who's taking 4 times the amount of yak. And the direct harm from RCAB's takings is much less and does not necessarily cause direct transboundary harm in this instance. Under the Convention on Biological Diversity and the Rio Declaration, states have the sovereign right to exploit their own resources. And Article 1 of the CMS defines conservation status of a species as the sum of the influences acting upon it. So by the very terms of the CMS, Uruk is responsible in part for this transboundary harm that it claims relief under. And third, international law prioritizes development and human health rather than favoring one country's uses over another. The Rio Declaration on the Environment and Development establishes the right to development must be fulfilled so as to equitably meet developmental and environmental needs of present and future generations. Uruk should not have a veto power over RCAB's new innovation and new ideas. Gavectra is on the World Health Organization.
I had another question about that. I saw something in the compromis about captive breeding. Why isn't that a potential alternative to interfering with particularly the winter resting of these animals, and at least some of the record indicates the possibility of dying out by 2040. Why shouldn't RCAB have to focus more on captive breeding, even if that might be a bit less robust?
Your Excellency, RCAB is researching captive breeding. However, no human has ever successfully bred a yak in captivity, and Uruk is also attempting to do captive breeding, but it's currently not possible. All of this evidence suggests that the needs of people with insulin-related diseases should be treated at least equal to, rather than subsidiary to, the needs of traditional substance users in Uruk. And lastly, international law requires that these two countries share the burden of sustainability rather than putting it all on RCAB. Uruk has attempted to skirt those obligations by strong-arming the yak into Appendix 1 of the CMS. However, the CMS itself emphasizes that parties should take individually or cooperative action where appropriate to conserve a species in their own habitat. And Article 1 of the Convention on Biological Diversity emphasizes the objective to promote the fair and equitable sharing of the benefits arising out of the utilization of genetic resources. In this case, Uruk should be required to cooperate with RCAB and to decrease its own yak hunting rather than placing all of the burden of sustainability on RCAB. Both of these countries are party to all of these treaties, and both of these countries share.
Would you acknowledge that there's some limit on how many animals should be able to be killed in RCAB?
Yes, Your Excellency. Certainly the number that would cause transboundary harm. However, in this case, we can't be sure that RCAB is causing that transboundary harm with its 1/4 of the size of hunting as Uruk.
Agent, I'm still pondering over the way you opened your statement, which is that international law should support innovation. And could you talk a bit more about what authorities you're marshalling in support of that claim? Often we're not told that we do that.
Yes, Your Excellency. I'm primarily relying on the Rio Declaration on Environment and Development, which establishes the principle to achieve sustainable development and a higher quality of life for all people, and that human beings are the center of concerns for sustainable development, and that they are entitled to a healthy and productive life with nature. And then reiterating that the right to development must be fulfilled so as to equitably meet developmental and environmental needs of everyone. And finally, I'd just like to emphasize that Article 32 of the Vienna Convention allows us to use supplementary means of interpretation when the interpretation of a treaty leads us to manifestly unreasonable results. For the foregoing reasons, this court should find in favor of respondent.
Thank you.
Thank you.
And we'll hear rebuttal.
Thank you, Your Excellencies. This court inquired earlier about the degree that they could look into the scientific necessity under the scientific purpose exception of Article 3. And I'd like to draw our attention to the Vienna Convention on the Law of Treaties, specifically their guidance on interpretation. They say that treaties should be interpreted in light of the object and purpose of that treaty. And certainly the object and purpose of Article 3 of the Convention on the Conservation of Migratory Species was not to provide blanket protection under scientific use for the mass slaughter of an endangered species, because that would be giving permission where there's no limiting principle. The company Dorta, for example, could perform a scientific experiment on one yak gallbladder, and that would trigger scientific protection to slaughter an unlimited number of yak. And for that reason, this court should find that slaughtering 28,000 yak within a 2-month period is not fitting strictly within that scientific purpose. There's ample evidence on the record.
I had a question about that. Should we consider at all the benefits to the world population of the killing of the yak? So imagine, not necessarily these facts, that hundreds of thousands of people would be saved by those 20,000 yaks. Would that be relevant to our consideration?
No, Your Excellency, would not be relevant to the scientific purpose unless something in that consideration spoke directly to the scientific aspect of it. The mere fact that it is saving a human life doesn't actually help it fit into scientific purpose. Perhaps it's extraordinary circumstance, except even in that case, there would be no imminence to the extraordinary circumstance. Finally, going back to the attribution of authority, whether this court finds that Dorta was a public entity or a private entity, under customary international law, even the risk of transboundary harm obligated the nation of Rakab to do everything within their power to use all means at their disposal, which is a very high standard. I see my time has expired. May I briefly conclude?
Yes, please.
Rakab has violated their obligation under customary international law. They violated the CMS Treaty Article 3. And for that reason, we request that this court hold them responsible for those violations. Thank you.
Thank you. Thanks to both agents.
We're now going to let the judges step out into the hallway briefly to deliberate and decide on a winner. We ask that everyone just stay here for about 5 minutes while they deliberate and come to a decision, and then they'll announce the winner right after that. So thank you.
Comments?
Yeah, please.
You want that before?
Interview that will have a lot of submissions.
You guys were both fantastic, by the way.
Yeah, good.
You guys were the first ones.
Well, I know
Really
because I made it while you were giving the presentation.
You struck terror.
Well, I already so it was just a matter of shifting it.
You as well, fantastic.
You got about halfway through your presentation. I was like,
None of
this is
you,
pretty
you're not a
self-explanatory.
JDL one, right? None of.
It's a super easy system
It is.
to use,
It
which
is.
is really nice.
Yeah, no, I've been happy to see that everybody's.
Which is great. I was
Actually,
surprised
that
at how low
pizza
the
right now is
API
the
was
coldest
for
thing
the-
ever.
It's only 72, but it still
You
looks
can
good on
appreciate
the
all the
TV.
flavors.
I don't either. I would have thought it had been like
You guys like
300. Yes.
I think her reaction was no chance.
I had that cold pasta yesterday. That was.
Was that good?
I weren't sure
Change.
I
heard compliments are pretty cool.
I feel
Well,
like
and the
cold
next-
pasta not
So I
like
worked
salad.
in
Like,
development.
I still
for a
don't
couple years
fully
before law school,
understand
and that
the
included
cold
doing
pasta
some, like,
salad.
marketing,
Like,
graphic design
I'm
stuff.
going to have that,
I had
like,
my do provided design
kind of
software
once
and
that
that makes me
instantly just out.
like, because you mentioned Canva, and I really like
I know.
Canva, but
Huge fan of
sometimes,
Canva.
like if I
Keto-
upload my own
keto
image
salad?
and then download
Keto salad.
include one, I'm not always supposed to do resolution.
That was
Which, and that may just be a user error on my part, but I haven't, so I generally go on there and find the design that I want, and then read
Yeah, smart question.
the design, so that I, because I'm, yeah, I just feel like I get a higher quality image that
Yours
way.
introduced like the professional.
Something.
You introduced like the professional.
Co-director of like the internet.
I will say, most of the time that I have
Apparently
problems with
Helfer
is when
taught
I'm
that.
doing
So,
Case.
the wavelength
although
case.
digitally.
So I'm a JDL lab student, so wavelength case is like one of the major cases that's closed.
Fiscal legal
In
services
the,
is a
like,
nonprofit
international
firm in
class.
Nashville, North
Did I
Carolina.
budget?
No, you do not budget.
On their
Neither of you did budget.
When you're at the very bottom of the ladder, you do just.
I think there's a slide.
Yeah, whoever's
The cases as well.
putting out fires the most, you just like hop in and put out fires.
That was in the finals.
My graphic design skills when I
So this is, maybe we can share the secret. It is. Exactly. You're not so comes from the Jessup Cup, and actually was from last year. So basically, it's in Jessup Cup, and they also,
I'm not going.
I can tell you right now, since you're in the board as well. So I want to actually compete in the international Jessup Cup. No, I didn't. I do want to.
So maybe they now operate on like.
If you want to, that would be an option for you as well. Yeah, so no one has volunteered except me yet. You need at least 2. Regionals are Sunday in the US. And the finals have at least.
You did not.
It's pretty.
Oh my god, I felt so evil last night. Yeah, I was my college. James was in the car and he was like, cool.
I didn't believe it at all. I really thought you were
There's like a list of them, and I would say we sent a list beforehand.
He was like,
If you join, so if you want,
I don't know why you're saying. Yeah, for sure, that makes sense.
send your email to Mail Sept.
I should be.
She's the scholastic chick, so she knows with that.
All right.
The Frank committee, yes.
Right. Kurt, do you want to, and then maybe I'll start on the comments?
That would be great. We have done this before, and I think we have reached a decision, but this was honestly a tougher decision than it's been sometimes. Both of you are very strong. It's obvious you've done this a lot during the competition, and you've done well in arguing both of these sides. And I think you both argued both sides before, and that's a challenge as well. And it really was kind of tough because we thought both of you were really terrific. We ultimately thought that Daniel, you were probably somewhat stronger kind of at the oral advocacy elements. We'll have some suggestions for both of you along that dimension. That's a little bit easier to comment on as well. We thought at times, Alison, you were better on the substance on certain kinds of questions, showed really detailed knowledge of law and the facts, which is key. So this was a weighing in our mind, but we kind of decided in a closely divided vote to award the win to the applicant on that, Daniel. But a very tough decision, and we thought both of you did extremely well, and we have some specific thoughts about how the argument proceeded, which we'd like to share as
Sure.
Yeah.
Sure.
And we're happy to take questions, of course, as well.
So, I mean, all of these Jessup cases are always incredibly complicated, and you both did a great job of being able to really, it was clear you knew the facts, you knew the compromis, you knew the law. A couple of sort of specific suggestions in terms of good and bad things. So Daniel, your eye contact is super, really good. You kept us on point, which I thought was you were able to segue from the first issue to the second issue. I was getting worried that we were going to keep you down and then as soon as you saw an opportunity, you did it. That was great. I'm not sure I was fully convinced about the way you linked the two issues on the merits. So I have to puzzle through more the transboundary harm point being only relevant to state responsibility and then the environmental treaty violations being separate. I'm not sure that could have, I think, maybe switching over to Alison, given you an opportunity to say, as you did, look, this is shared sustainability, and to the extent there's transboundary environmental harm, both countries are involved. If that's the only basis, Your Excellencies, for state responsibility, then we can show you that there is none, right? So I think there was an opportunity that you missed to kind of link those two, but at the same time, I think you could have made more of it. By the end, I knew where you were going with that. I thought both of you in response to questions, so I was going to say fishing for the whaling case, and you gave it to me, right? And you also knew chapter and verse what the standard was, which I thought was exactly on point. That was really important. I thought you had a killer response to my question about what isn't RCAB limiting its right to exploit its resources, and you nailed the response to that. I mean, in terms of you saying yes, in fact, that's true, but it's a two-way street. You brought it back to that idea of shared responsibility. Maybe the last substantive point I wanted to make I thought what was hardest, Alison, for you was that third point, because it really was a cluster of about 5 or 6 points that the enforcement of the CMS Convention would violate various other international law principles. I think it would have been more effective if you had picked one of those principles in order to sort of really hammer it home. And my guess is the shared sustainability is kind of the subpoints among that, the strongest point, because it helps to turn, you could tell that Professor Bradley was interested in the fact that,
They've accused me of being too interested in the number of
yak
yaks in the sum.
But putting that aside.
I think yak obsessed. It's like that.
But, you know, that you could have, I think if you had hammered on that, it would have drawn on his concern, and it would have kind of given a coherence to I'm not disagreeing with you. I thought you demonstrated a lot of mastery into what those points were. I was on the merits convinced, but there were a lot of them, and there was a point in time where you may have noticed our questions kind of dropped off a little bit, and that was because we were sort of trying to process the different points that you were running to. So I think, you know, sometimes just the simple things, or, you know, kind of the core point is really what's going to get through on a particular message. I might have a couple of other things to say, but I'll stop there for now.
Please.
Yeah, so I'm also, congratulations to you both. I would, a couple of things that were really effective and a couple of things to think about, you know, going forward. Definitely both of you, has been said, knew the factual component of the brief, were very readily able to engage in those factual pieces, didn't overstate those factual pieces or understate them. So that was really, really great, and I'd encourage you to keep ensuring that you do that. Both of you engaged frames at the beginning of your oral argument. Again, effective, and encourage you to do that. I think maybe the challenge is how to continue that frame throughout the entire argument and to kind of keep on message around returning to that. So if you have a frame, it can be very hard to hold on to that frame when you have then you have incredibly complex arguments. It can be sometimes hard to know how to relate to the overarching frames. So, you know, I think as Professor Bradley mentioned, like substantively, you couldn't have been better in terms of understanding the legal claims, but it's a matter of how you frame those and how you convey those and reading your audience who know international law but are still trying to sort of figure out exactly where things are fitting together. And so don't be afraid to be more simple sometimes, even though it might pain you, like that you think you're downplaying an issue. Let the questions complexify as needed, but keeping it very simple would be really important. So again, I was really struck by the answer to the Whaling, the question around the standard review. Knowing the law was pretty exceptional, but it can be difficult to know how that gets processed when you present. Both of you made some use of the even if type arguments. I would probably want to see more of that. Even if arguments, right? So even if you don't accept me on this, we can go here. I'd want more of that. I thought that was a little bit, that could have been a bit more, you could have been a bit more nimble in your arguments in that regard. So thinking through that a little bit more as well, and opening up opportunities in that respect. I also really liked, and you both did this, and I'm really happy about this. This is definitely a shift from the last couple of years. You were really good at clearly stating a yes or no to the answers and then going into your explanation, like rather than front-loading the explanation. Like it was a very, very clear what stance you were taking on our questions, and so I'd encourage you to keep doing that. That's a big thing at Jessup that distinguishes often advocates from different countries around how they engage with questions, but you all listened to the question, gave a simple yes or no, and then proceeded, and that was fantastic, and I would encourage you to keep doing that in this space. That's it from me.
Great. I thought both of you did extremely well, and I've done a lot of these judging, and I've coached teams before, and you both are very strong at it. For all the reasons you just heard, I think both of you were both great on the... You know, in the Jessup, I've noticed over the years a mastery of the facts. If I had to choose one mastery, the facts. But I thought both of you were very good when we were pressing you about specific things, that you kind of knew the record and you didn't have to guess or search around for it, which is huge. I think it's huge in general, but it's particularly true. International law, I'm a big fan of it, but it often has a little bit less precedential material than you would find in domestic legal system. And judges, therefore, are going to... This is just a lesson also about any argument. Judges have a lot of flexibility on the law usually, particularly for appellate issues where there's disagreement about the law. Equitable arguments obviously need to be framed in legal terms, but they're quite important for how cases come up. So judges want to do the right thing to the extent the law seems to permit them to do that. And I thought both of you were sensitive to that. And so I was pressing right at the beginning about equities, about killing more yaks on your side than the other. You seem to not be surprised that might be a line of questioning. Which, by the way, in some technical sense, it's really not part of the issues before us. I mean, this is not a complaint against ORC, it's the other way around. And so I was pleased, actually, that you didn't say, oh, well, that's not part of the issues or something, because I was thinking if we're worried about sustainability, it's part of the background of what the complainant is doing, even if it's not technically one of the legal issues. So I was glad that you were willing to go with me a little while on that. Both of you, I think, both internalized a lesson that I've often emphasized to people, which is, and if you go out and do any oral arguments after you leave law school, just please do remember this, which is the questions are the good thing. If you're getting questions, it doesn't matter if you get to the rest of your outline, it really doesn't matter. First of all, you rarely win on oral argument. I hate to say it, even though both of you are very good at it. You tend to win on the briefs. It's just true. But when the judges are asking questions, that's your only hope of changing their outcome based on oral argument. It is never going to change because you're really a great speaker by itself. It could change occasionally. I've seen it happen when the judges are not quite sure, and I would just make sure, particularly in a small group. Now, if it's 9 justices, you might need to decide to abandon that one and go for the 8. But for 3, if you sense we're really worried about something, and I've asked something, and maybe Larry or Jayne has asked something on the same tack, I would be okay in the real world of just making sure you feel like you've done your best, and not necessarily, even if you mean you can't get to all of your points. I thought both of you were pretty good at that. I never felt like you were trying to rush past our questions, but I would encourage you, because I remember doing a moot court and feeling like, oh no, not too many questions. I actually there's a lot of other good points that you haven't heard from me about, and I think that's in real life. It's okay to be peppered with questions. That's actually a really good sign. And then both of you, I thought, were also pretty good at the following, which is I used to do debate in high school and college, and in debate, you would just make 100 arguments, and 99 are terrible and 1 is good. It didn't really matter for some reason in debate. In oral argument before courts, have a sense of what you really care the most about, and try to get those out, even if you don't get others. And so, some of the arguments in this problem are weaker than others, and so I actually think the arguments, for just to take one example about how this corporation is an organ of the state or something, are not super strong. So it's okay if you feel like you need to make that argument, and then to kind of quickly, if you're getting pushed, and I'm not saying you didn't, to move on to some kind of alternative framing. On the other side, I'm not sure the scientific exception is that strong either. I mean, so there's just, I just, without picking out any particular examples, it's important to decide where you think the judges are most likely to be persuaded, and sometimes it's not necessarily bad if you don't use all your arguments. And the only exception is if you're arguing somebody on death row or something, you got to give all your arguments. And then I argued one of those cases in front of some judges, and I said, for the record, I've got to preserve all of my arguments. This person on death row, but I'd like to focus on that third one because I think it's basically my strongest. And the judges were super happy with me because they didn't want to hear all 8 arguments or something in the record. And I thought you were both good at that, but this is a kind of problem where I really thought the quality, the strength of the arguments you were given was not all the same. And so it's important to kind of have a sense of that yourself.
Just one other point of praise for Allyson was you opened with a very bold opening, right? To innovate, right? And as Jayne said, we don't normally hear that on this court, right? And often, those openings are, things you think a lot about. You're trying to immediately catch the judge's attention. That works. But if you probe, the theme is not always backed up by the law or by the facts. And surprisingly to me, Professor Huckerby came back and asked you about, where you get the authority for innovation. And I was like, well, I'm glad she didn't ask me that question because I'm not really sure. And I thought you did a great job in going back to the relevant principles and being able to say, it's still a stretch, but you didn't blink. You clearly had a source that you were going to draw on to be able to defend your broad framing of the case. And I think at that point, if you had floundered at that moment, because that was such a strong opening and it was a theme throughout, would have been a problem. But to the contrary, you were able to go to sources that, the way you read them, arguably at least, and sufficiently supported the claim you were making. So that's tough to do, and it means you're really prepared. So, did you have any questions for us? about anything.
I have a question. Thank you for your feedback, first of all. I really appreciate all of it, and certainly you all being out here tonight. What do you think is the best way to handle the rebuttal? That's something I really struggle with. How to strategize with
Right.
Rebuttals are dangerous. I think you did fine, although it could have easily been the case that we could have piled on some more questions at that point. In general, it varies, of course. Depends on how well you're doing in the rest of the argument, I have to say. Sometimes you just have to go for broke in the rebuttal if you think things are not going well. If you think things are going well, short, and in a way usually not to invite new lines of inquiry.
Yes.
Those are a couple of points of advice. I have seen people who are doing very well in an argument get up for rebuttal, and their position is worse after they sit down because they just reminded some judges of some things that were bugging them that they had thought they had gotten over, but now they're not over, or they overstated how well they were, a proposition. They thought they should be dramatic in their rebuttal, so they stated it more strongly than quite would be accurate, just as a rhetorical flourish. That's a dangerous thing to do. And so one way that rebuttals are quite effective is if you think we've really gone after Alison on one question in particular, I would maybe just point that out and then conclude. In other words, see what I mean? Because you think we're already with you on that one. And don't remind us of some things where we might not be on you with you at that point, because I think you might end up on a note that's a little more questioning.
So very specifically in this instance, Daniel, scientific necessity was a good one to pick. I think it fits with what Professor Bradley had said. But after you got that question on that, I would not necessarily have gone back and talked about attribution, right? I mean, I know it feels like we want to hit both of the two key issues, but you got 2 minutes, right? And he took up 30 seconds of it in his question, and you answered his question.
Yeah.
You're basically done, right? So rather than sort of saying, oh yeah, and by the way, there's attribution too, and thank you very much, goodbye. And you managed to get it in, but at that point, even if you had 2 points, if you've got that question, take the one thing, if you feel like you've answered well to the question, which I think you did, then just say, that's it.
I agree with that.
Thank you.
Alison, anything? No.
Well, congratulations to both of you for making it to the final.